Your world just got more complicated. What does it mean for Canada? What does it mean for you? Welcome to a special edition of Nature Labs. I'm your host, Simon Jackson, and class starts right now. Peter Biro, thank you so much for taking the time to speak with Nature Labs. You're basically a regular around these parts. You've talked to us about the importance of democracy, about the intricate ways that our Constitution works, and of course, you helped us navigate what the notwithstanding clause means. But we're getting together today to discuss yet another chapter in sort of this unfolding way that our Constitution might bump up against minority and majority rights. And of course, your organization, Section 1, is based around discussing the reasonable limits principle, which is sort of being put to test in what was announced today, a memorandum of understanding between the federal government and Alberta. This agreement is broad. It covers many different areas, but the one that I want to start with is how this potentially impacts Indigenous rights, because of course, this is not the first time a pipeline has been proposed to BC's North Coast. The last time it basically got canned because Indigenous nations, particularly coastal First Nations, opposed it, and it was very clear they were going to probably win in the Supreme Court of Canada. Now the pipeline's back from the dead. This new MOU has been signed. Basically, do you think the circumstances are different, and what could this MOU mean in terms of Indigenous rights and what the coastal First Nations might do? Because they've been on the record today saying that this pipeline and tanker moratorium won't be changed.
That's right. And from what I understand, a number of leaders in the coastal First Nations and perhaps elsewhere as well within the First Nations community in Canada have already said that this project is dead on arrival, that it'll never be built because it'll never finally be approved with the consent following due consultation with First Nations. There's no question this is an important chapter in the evolving project that is reconciliation in the sense, because it's only in the context of efforts to move forward with projects that potentially affect or trench on Indigenous rights that we discover and develop the principles and the practices that give effect to the reconciliation project one way or another. It's important to begin by reminding ourselves that the court has made it very clear on more than one occasion that Section 35 is really the project of reconciliation itself. It's in the Constitution because it's intended to give us not only guidance, but a certain measure of actual regulation and control over the project of reconciliation between the settlers, i.e., represented by the Crown, and Indigenous persons and First Nations in Canada. So the project, which has been introduced, and in fact, it's been enacted as Bill C-5, is designed to establish national priorities for Canada at a moment when the country has acknowledged and the government has declared that we're in a state not so much of emergency, but of great urgency in the, against the backdrop of tariffs from Trump and environmental challenges from climate change and the quick pace of climate change and our failure, by the way, to live up to any of the commitments we've made at any of the COP conferences, and a Canadian economy that is suffering greatly, projecting recession possibly, projecting high unemployment, particularly in the youth sector, which is a constituency that I know Nature Labs is particularly concerned with. And so the idea is we've got to kickstart a Canadian economy that is more independent than it has been in the past 50, 60 years, where it has been tied and embedded in and integrated in completely, indeed dependent on the American economy. With tariffs and Trump's protectionist moves, the Carney government recognized that our sovereignty is on the line, not just because Donald Trump famously promised to make Canada the 51st state, but also because the Americans have a great deal of control over the fate of our economy, and we want to lessen our dependency on American power over our economic fate, if you will. So this One Canadian Economy Act is designed to kind of kickstart our economy. You'll note from the projects that have already been identified as priorities, that they're more or less all either directly or indirectly based on Canada's natural resources, which means that not much has changed since Confederation, when we were making our living off the fur trade, the cod fisheries, and the logging industry. It looks like we still are, in a sense. Now it's mining, oil and gas, all of the special minerals that now so particularly precious and prized for quantum computing and AI economy to come. So what does all this mean for Aboriginal rights? Well, under the case law that has been decided to date, the jurisprudence that issued from the Supreme Court of Canada, and there are a number of cases, but two in particular that I would draw your students' attention to: the Haida Nation case and the Tsilhqot'in Nation case. There are a number of others as well. But those two cases are predicated on a number of important concepts that we need to begin with. The first is this idea of the honor of the crown. The idea behind the honor of the crown, it goes all the way back to the Royal Proclamation of 1763, King George. But the principle is that in all its dealings with Aboriginal peoples, from the assertion of sovereignty to the resolution of claims and the implementation of treaties, the Crown must always act towards Indigenous persons and Aboriginal communities with honor. Essentially, that means that the Crown has a fiduciary duty, a very special duty. It's different from any contractual obligations that it has arising out of treaties per se. It goes much deeper than that. It's a duty to take care of the essential interest of Indigenous persons and First Nations in Canada. And when in doubt, to give the benefit of the doubt to Aboriginal claims, even if those claims are merely asserted and not yet established or proven. That becomes critical to what's going on with Bill C-5, because out of those cases that I mentioned comes a regime that has come to be known as the duty to consult and the duty to accommodate. It's a process that is intended to give expression to Aboriginal interests when any kind of Crown project, whether it involves the granting by the Crown of licenses to private interests to log or to mine, or whether it is a government of Canada or provincial or territorial project in its own right. The idea is to ensure that the Aboriginal interests that could be in any way implicated in the project in question or in the license or undertaking in question are considered. And the only way to consider Aboriginal interests is to hear from the First Nations themselves, rather than to take what we historically did, a rather paternalistic approach, which was everything gets decided in Ottawa. Rather than that paternalistic approach, the duty to consult requires government, whether it's the provincial government or the federal government. It is the Crown, all right, in the person of one of these levels of government, that must consult and hear from the First Nations who are implicated, to hear exactly what the implications are of the proposed project, to hear objections to the proposed project or particular concerns that are raised. And these are not just any old kinds of concerns. They are concerns that have to be grounded in Aboriginal rights or treaty rights of some kind. This duty to consult requires meaningful consultation. It's not a kind of check the box exercise. All right. We sent a memo. We asked a few questions. They got back to us. All right, we've done our duty. It's not that at all. Although I have to say, it looks like it was a bit of that in the case of Bill C-5, because over the course of just a few months, this legislation went from a proposal to a bill to a law. And there was some consultation, but the definition of that term will require greater review and scrutiny, which I presume it will get in a future court challenge. But let me just tell you something about how the regime is supposed to work. Even if a claim, whether it is a land claim, a claim to Aboriginal title, is merely asserted but not yet established, because there's a lot that goes into actually having the court recognize title. But even prior to the recognition of title, the Crown has a duty to take the claim seriously, or the claim to the right seriously, all right, whether it's land title or some other Aboriginal rights, such as hunting or fishing or use of some natural resource, okay? So the process of establishing the right is a fairly rigorous process itself. But even prior to it having been established and recognized, the Crown has an obligation to take it seriously. And if it's a relatively credible claim, even prior to having been proven, all right, there's a duty, a corresponding duty, to accommodate the concerns and the request for some sort of adjustment or accommodation to the project's execution, the proposed project's execution, in order to minimize any harm to the Aboriginal interest in question. But beyond that, if the right or the land claim is actually established, that duty to accommodate goes much higher, and it requires consent. The whole project then requires consent and not merely accommodation. And the only way that the Crown could override the consent requirement, if consent is not granted where it is required, because the Aboriginal right or land claim or treaty right has been established, is through a process of justification, very similar to the kind of justification exercise that takes place under Section 1 of the Charter. It's not a Section 1 analysis, but very similar to the reasonable limits analysis that goes on. There's a kind of proportionality analysis that is done. And the most important element of it is that the Crown has to demonstrate that the project, as conceived or as modified, minimally impairs the Aboriginal rights in question. It's a tall order for the Crown. Now, what's happened in Bill C-5 is that these national priorities that have been identified, and there will be new ones, they contemplate future national priority projects. Now, there's nothing wrong with establishing national priorities, great projects for the country. That's sometimes called nation building. That's how we got the railway system in this country. But the priorities that have already been established are essentially treated under this legislation as absolutely certain to be completed, so long as certain steps are taken satisfactorily along the way. They're not up in the air anymore, which means, and the language in the One Canadian Economy Act suggests that the only room for compromise or accommodation involves perhaps involving affected First Nations in the equity holdings of the project in question. In other words, giving First Nations a piece of the action. One thing that is not contemplated is the possibility that any of the projects identified as national priorities will simply not proceed because they meet a consultation roadblock. That's out of the question, which already seems to be quite inconsistent with the jurisprudence that's come down. If Canada has the ability to say that a project will be completed at some point, it certainly undermines the meaning of consultation as it's contemplated under Section 35. So in a sense, it's partly running roughshod over that process and turning it into a bit of a check the boxes project. But that may come back to haunt the government, because at some point, one can imagine that the Supreme Court is going to make a decision. And that decision could be very, very damaging to Canada. The way this is proceeding, they're going to do as much as they can to move these projects forward. The target is to complete all approvals within a 2-year period of the announcement of each new national priority. That's an incredibly short period when you think about it, within which to get the environmental audits done, and more importantly, or equally importantly, the First Nations consultations. You can imagine that, a pipeline that is going to go through a territory that over which there is a claim to Aboriginal title, which, by the way, for your students, and they may, of course, already appreciate this, is not the same thing as fee simple ownership in the common law property system. Very, very different. And one of the things that's so important about that distinction is that in the case of Aboriginal title, it is communal title, and it's indefinite title. It's intended to benefit all of the generations to come, not just current beneficiaries of that title. So it's not something that can ever be disposed of by First Nations. It's not something that can ever be sold. It can be used, but only in a way that is consistent with its sustainability and preservation for the benefit of all succeeding generations. Right? When you think about it that way, a national priorities project, which could have a devastating environmental impact or ecological impact on a tract of land that has been established ultimately, or over which there's a strong and credible claim of Aboriginal title because it's used for hunting, for fishing, and that there has been a demonstrated long-standing use and occupation for those purposes, that could have a very, very damaging impact on the ability of First Nations communities who effectively see themselves not as owners, but as stewards of this land over which they claim title. It's a relationship of stewardship. Will not be able to meet their own obligations to their descendants if government projects are approved without appropriate consultation and are subject to the limits that First Nations communities, in their own wisdom and their own judgment, insist on imposing in order to preserve these lands. We're in for court challenges for sure. In the meantime, the folks in Ottawa are not stupid. They understand all of this. Their case is one of urgency and importance in the national interest, and that's a reasonable case. And if they were smart, what they would do was make every effort now, even though projects have already been identified as national priorities under the Act, to work out as best they can accommodations with all of the affected First Nations communities, even though it's kind of consultation after the fact, because that consultation, to be meaningful, should have occurred prior to the identification process. But on the other side of all of this, there is another legal position, all right, which is, we've been talking about Aboriginal rights, but let's just talk about Parliament's position, the Government of Canada's position. There is something called peace, order, and good government. It is referenced, it's set out in the preamble to Section 91 of the Constitution Act 1867, formerly known as the British North America Act 1867. And that section, the entire Section 91, sets out Parliament's areas of exclusive jurisdiction, those matters over which it can legislate with exclusive authority, right? As opposed to the provinces who have exclusive authority over other areas, and that's set out in Section 92. Well, under Section 91, in the preamble, this peace, order, and good government clause, which has been the subject of so much jurisprudence throughout Canada's history, from the time of Confederation forward, has been found by the courts to contain 3 prongs, if you will. One is the gap branch, which we we're not concerned with here. That's those matters which haven't been enumerated anywhere in any part of the Constitution are residually assigned to Parliament. Then there's the emergency branch, all right, which must involve an emergency and must involve a measure that is temporary, all right, for it to fall into the emergency branch. And that allows Parliament in those kinds of emergency situations, and there haven't been that many, to invoke peace, order, and good government. And then there's the one that I think would apply here, and that is the national concern branch of the peace, order, and good government power, which would allow Parliament to assume jurisdiction over subject matter that ordinarily would either involve concurrent jurisdiction between provinces and Parliament or exclusive jurisdiction of the provinces, but which in the circumstances would not be workable because either you wouldn't get the cooperation of all of the provinces or the failure of provincial cooperation or provincial ability to participate and cooperate and collaborate with the rest of Canada would fundamentally sabotage the entire, or frustrate rather, the entire plan. So Parliament says, well, this is a matter of national concern. But if Parliament asserts that, and it may well, if there's a contested litigation over this, that may give Parliament a leg up on First Nations claims. However, it's difficult to predict because we've never seen Section 35 rights go up against a peace, order, and good government claim at the Supreme Court of Canada to date. And it may well be that the court says, well, Section 35 rights aren't negotiable. They can't be subordinated in that particular way. They can be overridden if the justification test that was laid out in Silkwatan and discussed elsewhere is passed. That was the test that I said earlier is kind of analogous to the Section 1 test. But the point is, there's lots of room for litigation over all of this. So we're in relatively uncharted territory here.
There's one thing you said there, and you said a lot that helped really encapsulate this entire moment, and with all the context that needs to be understood to understand the moment we're in. But the one line that you said that really struck me was that we could be in for kind of a world of problems. And to my eyes, I see several things happening here. You probably don't remember, but students can certainly remember by listening to it. Our initial sort of your feature podcast with us, you talk about how our relationship with Alberta, that we were kind of sleepwalking into a national unity crisis, and not addressing their concerns was no way to go about nation building. Well, certainly, as you mentioned, the Prime Minister was trying to address those issues and do a better job at nation building and address Alberta's issues. But in doing it in the way that he's done it, as you articulated, it seems like we're kind of trading one constitutional crisis for another. BC's upset, at least part of BC, and the government who's in power right now, they probably don't have much of a leg to stand on, but they're certainly going to be wanting to be heard. Quebec is wary of how BC's been treated. This could have political ramifications in that province with a PQ government potentially on deck there, pending the outcome of the next provincial election, which could bring back the sovereignty debate in that province. And of course, everything that you've just discussed within First Nations, which is more complex and meets the eye, right? Because you've got coastal First Nations who say they're not going to allow this to happen, and in any scenario, there's no accommodation that would be sufficient to meet their criteria. Whereas other First Nations, say around Fort McKay in the oil sands, who say they very much want to see this project proceed. So you've almost got competing Indigenous rights, some who are treated, some who are not treated, competing provincial rights, and what kind of say they have, and potentially a government who's trying to understandably address, as you say, maybe not an emergency, but certainly a very real and present urgency, while potentially trading one constitutional crisis for another. I guess the big question here is, are we really going to put our constitution on the line with this decision? Is there a chance that the courts are going to have to sort of reopen these issues of rights? And will the outcome of what the courts decide, could that have reverberations across sort of confederation and more broadly to our democracy? Because at the end of the day, you are sort of Mr. Reasonable Limits. You understand this issue particularly well because we really here are addressing minority rights versus majority rights, and even that kind of convoluted into different contexts within Indigenous nations, within different provinces. So what could this ramification, what is the long-term implication of today's announcement potentially for the Constitution, for Confederation, and most specifically for the future and health of our democracy?
Well, firstly, let me just commend you on the way you've just posed the question, because I think that the questions that you just asked within the big question that you put to me is probably more important for your students and for Canadians than any answer I can give you, because you've identified a number of issues and problems exactly the way I think we should identify them. And ultimately, the challenges for us as a country, not just as a bunch of lawyers before the courts, not just as First Nations dealing with the Crown, but as Canadians generally. The challenge is for us to work all of this out in a way that will work for us. Because I do think, and you started with this point, we've got a national unity problem, if not crisis, in this country. Secession looming, as it always does, in Quebec. Western alienation, which, by the way, in my respectful judgment, is not going to be in any way sort of mollified or appeased by anything that Mr. Carney has done in an MOU this week. Firstly, that MOU is just an MOU. There's so many hurdles to go through to turn that MOU into anything real. In a lot of ways, the importance of the MOU was, as you said, I think quite rightly, more about mollifying and appeasing Danielle Smith than it is about actually advancing the cause of national priorities and this one Canadian economy project as a practical matter. But I don't think that Danielle Smith can be bought that easily. And I don't think that the national unity issues in Western Canada are in any way ameliorated by what's going on here. And I'm not being cynical about it. I just think that's the realistic way of looking at it. Now, you said, is this about trading one constitutional crisis for another? I don't think it is, although that was a very interesting way of putting it. I think that all of the constitutional questions are going to be on the table. All of them are going to be on the table. And of course, when we talk about national unity, of course, we need now most definitely to include the commitment and allegiance of Canada's Indigenous communities to the project of Canada itself. One of the things that the Supreme Court has not yet decided, but it will, and I'm fairly confident I know how it will come out, is the question of whether there is actually an inherent right to self-government. Now, the right to Aboriginal self-government has already been upheld, but in every case, it's been tied to some kind of delegated authority created by statute. It hasn't yet been decided at the Supreme Court level. And the idea of inherent right to self-government means that the right to self-government is not derived from anything that Canada does or says, any right or undertaking that Canada gives, any legislation that it passes. It's not done under the auspices of Section 9124. The idea of an inherent right means that, when you go back to 1763 and the Royal Proclamation, which essentially recognized the presence, the prior existence on the lands of Indigenous peoples, although didn't go as far as recognizing the inherent right to govern themselves. We're going back conceptually to that moment when First Nations communities were governing themselves because they were governments by their very nature, but also by their very history. If and when the court decides that there is an inherent right to self-government, to Aboriginal self-government, the question will arise as to what the meaning of Canada's Constitution then is relative to these sovereign, self-governing nations, these First Nations? Do they have to have consented to, to submit to charter scrutiny or to the application of the Constitution in any way, shape, or form? One would think, of course, yes. So we're going to have all kinds of difficult mental gymnastics to do down the road. But the question of the place of Indigenous peoples and communities and First Nations in Confederation going forward has not yet been fully settled, even though the commitment to reconciliation it has clearly been made. It's clearly been made. But as my friend and brilliant Aboriginal rights lawyer Bruce Wright has said, reconciliation is doomed to fail because it involves combining a right with a lie, and that's going to lead to failure every time. The right being the right, of course, to self-government and all of the Aboriginal rights that attach to being an Indigenous person on Turtle Island. Right? On the one hand, with the lie on the other side, which is, the lie of colonialism, which is the doctrine of discovery, the idea that, when the Crown, takes possession of the lands, it's as though the settlers were the first persons on this land, and everything that follows, including the Constitution that now commits itself to reconciliation, under the auspices of Section 35, is itself a colonial project, even in its effort to decolonize to some degree, so to speak. So, there are a host of fantastically interesting questions here, even assuming that everyone on all sides, right, is acting in good faith. There are major challenges and major conflicts, and some of them are irreconcilable. And so, there's no question that the Supreme Court ultimately will have to step in, not by, it's not, the court doesn't create rights, but it defines them. It looks into the content of those rights, gives them a fulsome purposive definition for the purpose of understanding what they mean and what an infringement really is and what it looks like. When you look at a government action or a government statute or regulation in relation to a right, you're asking the question, in what way does it impair the right? In what way does it restrict or abridge the right? And to what extent and to what effect, right? That's the court's role. And where there are these irreconcilable conflicts, the court has to figure out some systematic, just way to dispose of those conflicts, to resolve them. That's what Section 25 of the Charter is intended to do. It's the provision in the Charter that addresses the problem of the clash between an individual right under the Charter that is claimed and established and an Aboriginal right that is raised or claimed in response or in defense to the individual rights claim. And the question is, well, if you've got a conflict between those two positions, what happens? And the court, in a case called Dixon and VGFN First Nation, set out a 4-point formula for how you go about disposing of that kind of attention. But the point here is that the court, is faced with trying to give effect and expression to the rights and interests of all of the parties to this bargain called Confederation, and to the individual citizens and communities. In fact, all persons, even non-citizens, under our Constitution.
This is the most prudent time to become involved inside students in democracy education, because you really need to understand your Constitution to understand the challenges we're facing and that we might be facing soon. So if you haven't already checked it out, I really encourage all of you to take part in the side program, part of Section 1's great efforts to basically, as you say, Peter, arm our civic immune system to understand how our democracy works and why it's so important to be good stewards of our democracy. I do want to finish with one last question, which seems to be sort of kind of the elephant in the room here, is it actually possible to balance majority will and minority rights, is it actually possible to do urgent things while also being thoughtful? Have we reached sort of the ultimate paradox that we can't overcome, and and could that potentially threaten everything we do going forward? A bit of an esoterical question to end on.
No, it's not esoterical. It's the real, it's the real challenge of liberal constitutionalism in the world. It's the difference between pure majoritarianism, which may as well be reducible to mob rule, okay, and liberal democracy. And I think the answer to the question is yes, it is possible. You call it, you ask the question, balancing majority interests and minority. That is part of the exercise that is undertaken in, for example, the Section 1 reasonable limits test. It's also what legislatures do every day of the week, at least in theory, in their deliberations, right? But at the end of the day, liberal democracy is predicated on the idea that individual rights are never subordinated to majority will simply because it's the majority. I mean, the majority is going to set the agenda often, not always. In fact, we know in politics that powerful minorities have a profoundly influential effect on the political agenda of the day. But, majorities ultimately elect government or form government, or pluralities at a minimum. But majorities make mistakes. And it's not just a question of, unwise policies. I mean, governments enact unwise laws all the time. They make mistakes. They discover that they've made mistakes and they try to fix it. But there's certain kinds of mistakes that they're not supposed to be able to make. And those are the mistakes that go to the very essential dignity of each and every person. That is, their fundamental rights and freedoms. And when those are abridged, that's the limit that sort of establishes the line of demarcation between what a majority can get away with doing and what it can't be allowed to do. And there's all kinds of accommodation that can go on. That's what the Section 1 test is. But let me just frame it for you in somewhat, you'll say, esoteric but philosophical terms, okay? A liberal democracy is about a certain measure of accountability, not just to the majority, but to each and every individual person. And what is it what is the quality or property of each individual person that has this much force and standing, or gives it this much standing in the discussion? Well, it is human dignity. And I argue that human dignity operates as the ultimate factor in the political accountability piece. How does it do that? Human dignity operates as the justiciable constraint on the exercise of public authority. So that even when majorities or legislatures pass laws that are acceptable to most of the body politic, if they transgress certain fundamental things, such as hurting or disregarding the human dignity, which is expressed through, for example, freedom to worship, freedom to speak, freedom to associate, freedom to assemble, the freedom to be free of discrimination on prohibited grounds, the freedom not to be deprived of one's right to life, liberty, and security of the person. Those are specific examples, specific enumerated instances of what in toto is what I'm calling basic human dignity. And when that human dignity is on the line, it operates through the litigation process, all right? At a minimum, through the litigation process, as what Jacob Weinrib, who's this wonderful constitutional scholar at Queen's University, refers to as a justiciable constraint, a constraint that is subject to adjudication by the court. That's what it makes it justiciable. A justiciable constraint, a constraint that qualifies as a criterion for judging whether the exercise of public authority, of political power, is acceptable or not. Not politically acceptable, morally acceptable. That's my esoteric answer to your question.
I love it. And I do want to say that I have a bit of experience with the issue that's about to be unfolding. I've, as some of you know, have worked on coastal issues in my life, in my past life. And I think this issue is extraordinarily complex, more complex than most people understand, more complex than most people will remember. I think we are in for, as you said earlier, Peter, uncharted waters. And I worry that they will be very, very stormy waters at that. I realize that for some of you, this will seem like a boring homework assignment, that we've gone way down a rabbit hole of constitutional law that seems irrelevant to your daily lives. I think we're going to see in the coming weeks and months how relevant this is to your lives. And I want you to realize how incredibly lucky you are to learn from someone like Peter Biro, who is, without question, one of the foremost constitutional scholars in our country. He's literally written a book on how some of these aspects of our Constitution works. We are going to enter into contentious times. In contentious times, we need to have a full understanding of the context and to understand that it's not just our opinion or our perspective that matters. There are laws and there are functions of our country that if we love our country, we have to understand so that we can put a check on our opinions and see the bigger picture. Peter Biro, for helping us understand that bigger picture and helping us understand where we're going. Thank you so much for that, for all that you do. And of course, again, I urge everyone who's listening to check out Section 1 and SIDE and be part of Peter's great program to help you be better stewards of our democracy.
Thank you so much, Simon.